Now, in our previous segment of the lecture, we were looking at the requirements of a valid contract. And we started by looking at the writing requirement. And we said that under the CISG, there is no writing requirement. So when you are looking for the elements of a valid contract, you don't need to think about was there a writing or not. Instead, what we'll look for is the presence of what we call mutual assent. Now, a valid contract under the CISG, in order to be valid under the CISG, the rules set out in the CISG, there must be mutual assent. Now, under the common law, I mean, you might recall this from your 3213 class. Under the common law, a contract arises when there is offer, acceptance, and consideration. Offer and acceptance together constitute mutual assent. So offer and acceptance is mutual assent. Now, under the common law and under this UCC, there's this other element called consideration. And consideration, again, kind of complicated, but essentially what it means is there must be something of value that passed from one party to the other. There must be something to seal the deal, to confirm the offer and the acceptance. There must be some amount paid. It's meant to be a bargain, and to determine whether there's a bargained for exchange, we look to see, did something of value pass from one party to the other? The CISG has no rules requiring consideration. So a valid contract under the CISG, you do not need to look for the presence of some value passing between the two. Now, ordinarily, there's going to be such a thing. However, if you have a contract where there is nothing of value and it's just an exchange of promises, as long as there is an offer and acceptance under the CISG, it is an enforceable contract. The CISG requires mutual assent, offer and acceptance. Let's look at offer first. What do we mean by offer? Well, under the CISG reflects the understanding that sales transactions can happen in a very rapid or casual manner. So the offer may not be something as clear-cut as I offer to sell you my computer for $500. It may be more loosely constructed than that. So how do we determine what is an effective offer? If I say something along the lines that, man, if somebody would pay me $500 for this computer, they could have it. Well, for an effective offer, for an offer to be effective, we look to see, did the offeror intend to be bound by the offer? Was there intent that accompanied that offer? So if in a lighthearted conversation, I was complaining about my computer and I said, well, you know, if somebody offered me $500, they could have this today. And then someone else overhears it and says, here's $500, and now I get the computer. Well, probably not. Why? Because that phraseology of saying if someone would give it to me, give me $500, I'd give them the computer, did not express serious intent. It did not express that I intended to offer the sale of the computer. So when we look at intent and we want to measure was there intent, we do it by looking at two components. And first of all, we look to see how many people was the offer addressed. How many people received the offer? If it is a low number of people, if you and your roommate are standing next to me and I say, here, I'll sell you my computer for $500, well, that clearly is an offer. There's just the two of you. If instead I send out a broadcast to every student at OSU, all 25,000 students, and say, by the way, I have a computer you may want to buy, I'll sell it for $500. Well, the greater the number of people, the less likely it is to be an offer. It's instead, when that happens is we say that's really an invitation to make an offer. That's an invitation for others to offer, to buy the good. The other aspect of whether there was serious intent, we look at the definiteness of the proposal. How definite was the proposal that was made? Now, in the international context, these offers could arise out of a number of different areas. Let's look at, well, first of all, let's look at a hypothetical. Say I send out a catalog to 200 different companies on a mailing list and that I've obtained from another vendor, and the mailing list identifies buyers who've purchased industrial equipment in the previous 2 years. If there is, if in this catalog there is a toolkit, and the toolkit sells for $50, and an American buyer sends in an order for 50 toolkits at $50 each, is there a contract? Well, the law would say probably not. Why is that? Well, there was a large number of people to whom the offer was addressed. Even though it was definite, it said $30. I mean, it said $50. There was a price for it. But it was sent to such a large number of people, 2,000 different companies, then that's probably not indicative of an offer. Now, if instead we had a case where the German seller tells an American buyer, we'll give you a discount if you order a large quantity of toolkits. And if the American buyer then responds by sending in an order for 100 toolkits at $45 each, is there a contract? Well, no, because the offer was not sufficiently definite. We'll give you a discount. How much discount's not named. If you order a large quantity, what's a large quantity? Not contained. Therefore, that indicates that's probably not an offer, even if it's just made to one individual. So on your test, when this comes up, look to see how many people are receiving this transmission and how definite is the transmission. And both aspects have to be there. Now, if a seller makes an offer, the seller has the right to withdraw the offer at any time before the offer reaches the offeree. So if I send a catalog, or if I send an invitation to sell a good to a customer, and I note after the fact that I quoted him the wrong price, as long as the offeree has not received the offer, I have a right to withdraw it. So anytime before acceptance, I can withdraw my offer. That means it is a revocable offer. Now, once the offer has reached the offeree, the offer may become irrevocable. Now, the general rule is that an offer can be withdrawn at any time before acceptance. This is the common law practice. The common law says that an offer is not binding unless there has been money paid to make the offer binding. So if I send an offer and offering to sell you a good for $500 and you get it anytime before acceptance, I can withdraw that. Matter of fact, even if I say, look, I'll offer to sell the computer for $500 and I'll leave that offer open until Friday afternoon at 5 p.m. If on Thursday morning I decide to withdraw that offer, under the common law, I can. Now, in the event of or in the case of the UCC, generally the same thing applies. You can withdraw an offer at any time before acceptance. However, we have in the UCC what's called a firm offer. A firm offer says that if a seller intends to hold an offer open and expresses that intent in writing, and it's for a limited amount of time, then that offer becomes irrevocable. The firm offer under the UCC. This is the rule of the CISG, except there's not any of the requirements. If I communicate that the offer is going to stay open until Friday at 5 p.m., the offer will stay open. I lose the right to withdraw my offer, to revoke my offer. At that point, it has become irrevocable. And under the CISG, these firm offers are valid even if they're not in writing. So how's this going to come up on your test? If there's a situation in which there is an offer made and the seller says, I intend to keep this offer open for the next 48 hours, if it's under the CISG, the seller loses the right to revoke that offer. It has become irrevocable. So general rule, I can withdraw my offer at any time. I can revoke my offer at any time. However, if I've made a firm offer, I cannot. I am bound by the terms of the firm offer.